Thank you for staying with us. That's the conversation we're having this morning. Reactions have, of course, been coming in about that judgment. The PDP, for instance, has also put out its own statement. The PDP is appalled by the judgment of the Supreme Court in the petition filed by the PDP and presidential candidate, Atiku Abubakar, against the declaration of the All Progressive Congress and Bola Ahmed Tinubu as winners of the February 25, 2023 presidential election by the Independent National Electoral Commission, INEC. Goes on to say down the line that Nigerians earnestly expected the Supreme Court to uphold and defend the clear provisions of the 1999 Constitution in terms of qualification and minimum requirement for a winner to be declared in a presidential election in Nigeria, especially with regards to the required statutory 25% of votes in the FCT, as well as issues of violation of electoral rules and guidelines, brazen manipulations and alterations of election results by the APC. Well, on and on, of course, at the bottom of the page, the letter signed, the statement signed by the PDP's National Publicity Secretary says, the PDP remains undeterred and charges Nigerians not to be discouraged or allow the judgment to detract from their collective quest for the entrenchment of a credible electoral system and can guarantee a government that truly derives its legitimacy from the people. That's a statement of the PDP on that matter, but we have two gentlemen who are here to review that judgment of the Supreme Court, where all grounds of the parties failed as the court upheld the election of the president as having been duly elected. That's a statement of the PDP, as we read to you the other time. But that's the reality that we have on our hands. As I said, two gentlemen joined us this morning, both of them senior advocates of Nigeria. Professor Paul Ananaba is here with us. He's a senior advocate of Nigeria, as I mentioned, and he's counsel to the Labour Party. Thank you for joining us this morning.
Thank you.
Of course, your party has responded and all of that. But generally, by way of an understanding, what's your take on the judgment? I have a general idea, but I'm not you.
Well, I'm not speaking for the party.
Okay.
When you act for a party in a case and final judgment has been given at the Supreme Court, you are no longer talking about as a counsel in the case. You have a higher calling to justice, to patriotism, nationalism, and the best interest of the society. So I do not speak for the party at this point, or for the candidates. The judgment of the Supreme Court is part of their duties under the Constitution and the Supreme Court Act. They have done their duty. There's no way that judgment, which is a political case, will be accepted by everybody. And there's no way that judgment will be perfect. But before talking about that judgment, I want to appreciate the fact that at least in this run of election, despite the volatility and the concerns, the parties decided to go through the court system. And that is why we can sit down and discuss. If there were violence, I can't even leave my house or my office to come here. So that at least we have achieved one culture of realizing that, oh, we can go to court. And I think that it now also goes beyond the Supreme Court decision. There are certain aspects of that decision that I believe will have to be addressed by legislation. So the Electoral Act needs to be amended now. And not an amendment by persons who are not practitioners. That's why we've been failing in our amendments. And we keep them
practitioners in terms of?
In terms of politicians and much more election petition practitioners. And then there'll be a few of regulators. Because it's not about who won or who lost. But the judgment will have a trickling effect on the governorship petitions that are going to the Supreme Court, on the National Assembly petitions that are in the Court of Appeal now.
So which aspects in particular are you asking to be adjusted?
There are so many. In the first place, why do we need 180 days for a petition? Another 60 days Court of Appeal, another 60 days Supreme Court. There is no reason why every election in Nigeria cannot be concluded within 60 days, petitions, and before anybody is sworn in at all. Yeah, we will say yes, the courts have given judgment, yes, but it's data if nobody has been sworn in and elections are taken clearly. Let me give you an example. Within 2 months of every election, including the presidential, you can determine the petition that may arise to finality.
Are you sure that is possible? Because one of the issues...
let me tell you how. Okay. I'm a practitioner.
The reason I'm asking, and you take us through it,
yes,
is there's so much data to collate.
Let me tell you why.
Okay.
If INEC is given 7 days after election and declaration of results to forward and put in their website all electoral results, in any event, one, all the panelists in all the tribunals will have the results. All the political parties will have the results. It will be there in MVA. Within another 7 days, that makes it 14 days. Every person who has a complaint, who is having a complaint, will now limit the complaint clearly within the results declared. Do you understand?
Okay.
Now, it goes into what has been transmitted. Now, within another 7 days, which is 21 days, the tribunal will sit on this as identified areas. You no longer need INEC, give me CTC, don't give me CTC. And INEC will not be a party in terms of being a respondent. INEC will be an independent party to answer to any issue pertaining to them.
Okay.
Now, let me land it. I have taken away 21 days. Within 7 days, every tribunal will determine, you have seen the Supreme Court. I mean, processes are before them. Within 3 days, they gave judgment. So, within 7 days, each tribunal, maximum 14 days, will review whatever complaints. Looking at the result, everybody has the result. There's no issue of it's not certified, INEC did not give me, everything is there. You don't need to call polling unit agents again. Section 137 works out. In 1 month, tribunal finished. Another 2 weeks. If you have a complaint, within 7 days, take it to the Court of Appeal. The Court of Appeal, in 7 days, determines, because it will now be on the narrow compass. You want to go to Supreme Court further, another 2 weeks, it is done.
Okay. Well, as I said, there are 2 of you generally joining us this morning. The other fellow is in Abuja with my colleagues. Go ahead, Chamberlain.
Thank you, Ayo. Mr. Adebayo, Senior Advocate of Nigeria, is here with us. Good morning and thank you for coming on today.
Good morning.
Well, yeah, the judgment is, impressions are all out there, but could you give us an inkling into what the thinking, the impression of the legal team could be, or it was, or it still is, probably?
Yes. Let me say this. I think after the election, you brought in on this program Mr. Andy Johnson, SCN, who analyzed the role and the nature of what the legal team who intend to fight this petition will be. And he made reference to the legal team in US. And believe me, the APC and the presidential legal team were not set up after the declaration of result. We've been in place 2 months before the election was held. And the team was under strict supervision by former Minister of Works, Babatunde Fasola. He assembled the team. He assembled that team. And the team had been meeting ever before the election was held. And after the declaration of result, and when others were just running and scatter, groping in the dark, they didn't know what to do, we had in place our defense already. And you can imagine, we were not mistaken what would be the outcome of those petitions. And we were proof right yesterday when the Supreme Court affirmed unanimously the decision of the Court of Appeal. So it was a tag team, solid cast team, which you cannot get anywhere in this country because it parades the best of seasoned legal personnel. You can imagine, if you have in any team, the current Attorney General of Federation, before he was appointed, Latif Fagbemi, Malam Ali, Tarimon Lajo, Tayo Tibo, and what have you? Believe me, without being immodest, you cannot get it better anywhere. It's an imbalanced team. When you play side by side, that team with the team on all the other side will be defied. So the result, obvious. And that was the excellent result. You know, at the Court of Appeal, it was unanimous. Likewise, yesterday, it was unanimous. And that's 5-0, the Court of Appeal, then 7-2 yesterday. And people can say whatever they like, politicians. And like one, I think it was an Arabic prophet who said, where ignorant is bliss, the wise is foolish. How will those 12 people be wrong? Can those 12 people, 5 at the Court of Appeal, 7 at the Supreme Court, can they be wrong? So yes, anybody who says anything or anything otherwise to have his examine. That's it.
Well, we'll examine part of what Mr. Ananaba has said now, but we've also heard people who looked at it in the context of probably history, where they just felt, look, after all, no courts, no time has any presidential election in this country been upturned, no matter the reasons. And so they just felt, who knows, if they look at it in that context, perhaps, I know you may think it might be out of context, considering the what you just told us, how this was set up.
It was lack. You know, when you prepare to fail, when you prepare to plan, it means you've prepared to fail.
Okay.
They didn't prepare very well.
Yeah, but some of the things that came through, part of what suggestions that Professor Ananaba is giving now, which is the role of the umpire, INEC. So if they're supposed to be the umpire, and then they appear in this case to defend themselves, should we actually have a second look at that and see, okay, look, in order for people not to get the wrong impression, as though they are always on one side when this kind of cases come up, we follow some of the examples he said, look, let me be an independent body, so that when they come through, perhaps their position can be properly distilled to everybody else.
I don't agree with him. You see, one of our current problems in this country is that we are fond of citing example elsewhere without thinking of our peculiar circumstances here. Look at when the Naira swap, when the new Naira was. People are saying it's good. You can do electronic banking. How many Nigerians have access to banking, not to talk of access to electronic banking? How many of us? Where I come from, it's an urban local government, and South local government, under the former municipal. Before you could get bank facilities from my area to another place in local government, you will have to take about 2 buses. You get my point? So what are we talking about? You see, in Kenya, where most people refer to, where there's petition, where it will be it will have been concluded before the winner will be sworn in. It's only one level. That's at the Supreme Court. They don't start from the Court of Appeal. They start at the Supreme Court. And you see, in Kenya, it is not, they don't practice adversary proceeding, which we do. Their own system is inquisitorial. I watched the first one where President Uhuru Kenyatta election was nullified. That's Raila, Odinga, and Kenyatta. Yeah. And I also watched the second one. In fact, I have them. Most of them were commenting. They don't even have it. They don't have it. They don't want it. In fact, when the first one was done, I was in Kenya at that time. And let me say this. In Kenya, their own electoral umpire is called Independent Electoral and Boundary Commission. They do two things. They conduct election. They are also they settle boundary dispute. It is in custodial. And they are conducted. Their cases are fought on affidavit evidence alone. And when you look at their lawyers, you will even see them giving evidence. Why conducting their proceeding? Yeah, a lawyer must not give evidence. You call witnesses who will give evidence. And people are now saying, no, I've asked them, how do we, tell me, the only thing that you can do is that we can see the goalpost. You can conduct our election maybe 9 months before the swearing-in days. 9 months before, so that we have enough time to conclude all those cases. And again, the presidential election, we can also narrow down the issues. It is not. Yeah, it is not all infractions that you bring to court.
Mr. Joe, we've heard, I'm sure you also have heard people say, look, it is incredibly difficult to prove any case beyond reasonable doubt or go out of the realm of substantial compliance.
Unless some persons are not proved beyond reasonable doubt. It is civil. For those sui generis, it has to be proved on matter of probability. But it's only when you raise issues that are criminal in nature that you have to prove that, and not all criminal in natures, when it is collateral to the main issue involved, then you have to prove it. You understand that? And we talk of honor and Nwobodo, Ajasin and Nwobodo, and cases like that and that. You know my point? So it is not new. It is nothing new. Honor and Nwobodo was decided after the 1993 election, likewise Ajasin and Nwobodo, after 1993, during the Second Republic. So they are nothing new. And they've always been there in our electoral jurisprudency. What am I saying is this. Let us conduct our election well ahead of the time. And you see, when people are saying,
but how does that change anything?
When people are saying you can do it before the swearing, they've forgotten that Ross justice is not justice. Ross justice is not justice.
But do you support the idea? Do you agree with the idea, the principle, that it is only right that if there's been a dispute with regards to election, it should be resolved before swearing in?
Yes, that's why I said we need to have the election well ahead of the time.
No, it's very.
You see, when we started this,
when
we started this national democracy, I was in Ajimobi and Nakada in 2007. It took us over 2.5 years before we could get judgment at the first tribunal, and it also went on to the Court of Appeal. You know, we all remember how long it took former Governor Aregbesola before he could get judgment. Likewise, Governor Adam Oshiomhole. In fact, Fayemi was close to 4 years. Some people have even spent their time there. But now we have 180 days, 60 days, and 60 days. But one thing I would like to suggest is this.
Former Governor Peter Obi, who was a candidate in this election. But the point is this. I mean, the thing is, if we agree on the principle, then and there is consensus on that, some people will say that finding a way to achieve it will not be a problem.
Yes.
But, you know, let's leave that aside. Listening to the judgment of the Supreme Court, of the Supreme Court justices yesterday, what immediately came to my mind again, because we saw the role that technology played in this election and the role it was supposed to play, and how it fell short once again, and it would seem that a lot of Nigerians were very disappointed as a result of that. It was part of the reasons, it was part of the issues that were tabled before the Lord Justices yesterday, the role of IREV and the transmission of results, which they seem to have dealt very decisively with that. The results itself was more important than how it was transmitted. And what immediately came to my mind was the issue of the card reader. When in 2015, INEC introduced the card reader, and it was supposed to be a fantastic innovation that should reduce fraud in the elections. And we found out that, yes, it did help in many places, but in some places it didn't work and it was abused. The leeway that was given for incidence forms were abused. And even where, it wasn't abused, where the evidence produced by the results from the card reader, were useful or could have been useful to show that fraud actually happened in some places, we were told that it was not a part of the law. And so people couldn't, the litigants couldn't send out this evidence before their lordships. And then, they had to go back and incorporate it into our laws. It seems that we're back there again, where we have put another innovation. This time, not very clearly, it's been ambiguous in the law. So it does appear that we're back again. We're going to have to go back again to re-amend our laws, because it would seem that that's where the problem does lie. Do you agree with that?
I don't agree with you, because this last election, 2023, use of incidence form was not allowed. I went to my poll unit with my wife, my daughter, and a friend. My daughter and my wife, they are Labour Party adherents. I'm for APC, while my friend wanted to vote for PDP. But I couldn't vote because the card reader could not authenticate.
There was no card reader, it was BVAS.
No, BVAS. The BVAS could not authenticate his thumbprint. And when they tried to do the Irish one for him, it could not. So, if it had been under the 2015, they would have asked him to fill it incident form and it would have been allowed. And you see that use of the BVAS reduced substantially. We all knew the results that were always coming from Kaduna, Kano, and Katsina State, even Rivers and Lagos State. But it was not so under this just concluded election. In fact, I sympathize with INEC. Recently, I saw Mr. Festus Okoye during the Friday office of Justice Aminaogi, and I said, you people, how are you be able to sleep? That's why I said, it's like all your effort have been rubbish just because of failure to transmit all the results on the IRF. And look at you like, what is IRF? You see, media, and let me say, with respect to people, you assisted those who were making mere lamentations. You hyped them. Look, I belong to over 150 WhatsApp groups, platform. Serious one. Making up, in fact, in one, my learned senior, Polanaba, is there. I challenged all them. I said, let me see one person here who can come out and say, when my polling unit result was later published, or was later shown on the RF, it was different from that what was declared at the polling unit. And nobody, up to today.
Just a moment.
Nobody.
No, just a moment, Mr. Adebayo. There were people who actually showed that.
Have you seen them? Have you seen any?
No, just a moment.
No, let me ask you, I've not seen any, and I'm even challenging them to today. Look.
Are you saying then that all of the other pictures,
propaganda, we were the tribunal.
Just a moment.
Look, let me tell you, let me say this. When they brought some, they said it was blood. In areas where they themselves won, where they go in Southeast State, they brought some blood election result. In area where if it was blood from the RF, was it blood in the one day? You have party agents all over.
Okay, so
why can't you collect your party agents home or collect from the security agency?
Are you saying then, just a moment, are you saying then that you see no need to amend our laws any further?
The laws will be amended now. If we're in line with the judgment that was deferred as for yesterday.
All right.
Because
what should the law be amended to reflect?
No. For example now, like I said, we must conduct our election way ahead so that all the legal processes will be completed before the winner, the person who has been a judge winner is sworn in. But I don't believe in abridging the time. Even 21 days that were given to them, they couldn't put up something tangible or which is solid cash because of lack of time. Because every duty, other duty is imposed on the prisoner rather than, and that's why people like us, I don't file petitions. Right. I only defend.
Okay.
I only defend.
Let's go to Lagos. Ayo.
Well, Chamberlain, well, Prof, I know you may have a reaction or two, but I just want to, I don't know if we can just quickly go to some of the, or you want to quickly react to something?
No, I'm not reacting.
Okay. One of the issues that was decided yesterday by the Supreme Court was that some issues that have been litigated shouldn't have been brought to the court at all, should not be relitigated. They cited the example, for instance, of the issue of APC's double nomination of Vice President Kashim Shettima, that it had earlier been decided by the court on May 26, 2023, and to have been brought back again was something that, according to them, it shouldn't have happened in the first place. Why do you think that kind of thing happens?
You want me to...
I mean, it's this what the Supreme Court says. So, I mean, excuse me.
Well, that's the decision of the Supreme Court, and we're bound by it.
Okay.
But also, we are taught in the first year in the university, when you are taught the Nigerian legal system, you will be taught that there can be two cases like that, and you go back, when another one comes up to the Supreme Court, it can be distinguished, and there may be a reason for the Supreme Court to review and know whether it will change its mind. Now, if a decision is wrong, or is perceived to be wrong by a person, or that the Supreme Court has given a decision on a point, does not mean that that it is now cast on stone. Some of them may have to be reviewed over time. So I'm not going to join issues with the justices on why they felt that way. But I believe that...
but this pardon me for jumping in, this case doesn't look like it was something similar. It was the exact same case of double nomination.
Yes. Like I said, I don't want to join issues on that. If you get into that case, many tribunals took that PDP case out of context. And based on that, every other petition, many persons or litigants suffered from it. What I mean is, that means that, when you talk about nomination, that every issue of nomination is now a pre-election matter. Now, that's what many tribunals made out of that decision. And based on it, you will now start having chorus judgments. Yes, in some instances, if a law is settled, you don't need to... A fair position is settled. It becomes a time-honored principle. But sometimes it's not a computer thing. It's if there is a reason to bring back that same issue, to say, my lords, look at it again.
Okay. But just one quick thing, and then we go back to Abuja. Talk to us about what Nigerians should do, understand, or expect going forward. Yes, no doubt, the drove of people that voted against the president are not happy with the judgment. There is no doubt about that. However, the law is the law. The Supreme Court is the Supreme Court. The judgment of the Supreme Court stands as the Supreme Court. With the disappointments that people have had and the kind of expressions that we're having, that seems to be, as you said, looking like we are remonstrating the decision of the Supreme Court. What should we be telling our people so that our system, the judiciary, particularly the Supreme Court, is not denigrated?
All right. Those are part of the issues I was raising, that we should be having the National Assembly do its work. When you look at the Constitution, you have Section 4, Section 5, Section 6. Section 4 should be kicked in. Let the National Assembly look at the Electoral Act, and we thoroughly do a realistic and practicable and Nigeria-tailored electoral act.
Okay.
And we can start down, not 2 or 3 years or a year to the elections. This is so that electoral matters are political matters. The courts are not well fitted for political cases. That's not, and that is what allows politicians to begin to push on judges, try to destabilize the system, wanting judges to behave like politicians. That's part of the debilitating things you see.
Okay. All right.
Going forward, the National Assembly should amend the Electoral Act in an enduring manner. And I've told you, for example, one is INEC. INEC should no longer be a respondent.
Okay.
And the proof, onus of proof of every electoral issue should now be moved to INEC, not on the party.
Okay.
Now, when you have that, things like the state of subpoena now, after that decision, should be reviewed so that subpoenas can be used.
I'm suspecting that maybe by you or by a body of lawyers like yourself, you're going to have to give us a compendium so that the National Assembly can have something to look at. But now we have to thank you very much for your time. Professor Paul Ananaba is a senior advocate of Nigeria. Thank you so much for your time this morning.
Thank you.
Chamberlain and Malwe.
Well, yeah, so as we also wind down here, Mr. Ojo, so moving forward, you know, when you say, you all say that justice should not just be done, but it must be seen to have been done. So moving forward, in order for a lot more people to also be of that impression that whatever is handed down is seen to be justice, those amendments that he suggested, would they be ideal?
Yes, like the most important one, that we should conduct our election well ahead of time. That we should have factored in the 180 days, the 60 days, and 60 days. And again, more importantly, you see, presidential election, 2 levels of court, Court of Appeal and Supreme Court. National Assembly, 2 levels of court. And why must the governorship be an exception? Which is 3 levels of court. No, that one's also be reduced to 2 levels of court. If we may start from the Court of Appeal and end at Supreme Court, or if they like, let them start from the tribunal and let it terminate Court of Appeal as it used to be. But the onus of proof, that can only be done if we want to change our Evidence Act. Because Evidence Act has fixed it that he who has had must prove, and it can't be otherwise. And INEC, who is the party that's really charged to conduct election, must be a party.
We cannot make exceptions in the Evidence Act.
That would be turning the law on its head.
You say except in electoral matters.
Yes.
I mean, that's what I'm saying.
I know West Panel suggested that. But INEC is not the one asserting. INEC has conducted election, and INEC said this election that I conducted. So it's like asking asking a defendant in criminal trial to establish his innocence. No, it's not possible. It is the prosecutor who must prove that he's guilty beyond single doubt.
All right, it's an unending conversation, so probably we'll see how the National Assembly internalizes or takes all of this on board to see what can be described as the best position moving forward. Thank you for coming on as well.
Thank you for having me.
Mr. Adebayo, Senior Advocate of Nigeria. Well, back in a moment. Stay with us.